Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Livelaw. We bring you the latest and in-depth legal coverage. Here is a brief of what all happened in the Indian courts today. Starting with the Supreme Court, which has acquitted a father-son duo in a 27-year-old murder case who were convicted by the Sessions Court and High Court and were sentenced to life imprisonment for committing murder. The acquittal was granted based on benefit of doubt and the failure of prosecution to prove the appellants had committed the offence beyond any reasonable doubt. Altaf Hussain allegedly had certain land dispute with Muhammad Muslim and Shamshad, the appellants in the case. As per the prosecution's version, in 1995, Altaf was going on a bicycle with his son and nephew when the appellants assaulted him with an axe and he died. In 1998, the Sessions Court convicted the appellants and sentenced them to life imprisonment, which was upheld by the High Court in 2010. Consequently, in 2011, the appellants filed an appeal before the Supreme Court. The bench, comprising Justice V. Ram Subramanian and Justice Pankaj Mittal, while acquitting the appellants, took the view that the behavior of Altaf's son and nephew appeared unnatural. They did not intervene when their father was allegedly being assaulted by the appellants. In fact, two other people came to save the deceased from a distance. The deceased was never even taken to the hospital, but an FIR was lodged immediately. Thus, in absence of any credible eyewitnesses to the incident, the court accorded benefit of doubt to both the accused appellants. The Madras High Court came down heavily on the Madras Bar Association for its strict bylaws, making it difficult for an ordinary lawyer to become a member of the association. The present case was filed by senior advocate E. Rajendran, who alleged that his son was prevented from drinking water at the MBA hall by another senior advocate in 2012. Among other things, he also contended that the association did not follow a transparent and democratic guideline while admitting members, and that at various instances, the association had arbitrarily not considered the membership application of different persons. Justice S. M. Subramaniam noted that the bylaws of the association had been formulated in such a manner that ordinary advocates found it difficult to get membership, thus resulting in class discrimination. The court also noted that since the association was functioning inside the court premises and enjoying all benefits, including free electricity, such elitism could not be allowed in a public place. Further, the court also directed the association to pay 5 lakh rupees as compensation to senior advocate E.G. Rajendran for denial of drinking water to his son. The court also significantly observed that untouchability was not merely a caste-based practice, but included all practices of social exclusion that have their basis in ritual ideas of purity and subordination. A court in the national capital has acquitted Delhi Minister Raj Anand and Aam Aadmi Party councillor Ankush Garg in a case related to a protest held near the residence of former Delhi BJP President Adesh Kumar Gupta in March last year. The AAP leaders were booked under Section 188 read with 34 of IPC for disobedience of order duly promulgated by a public servant. Delhi police accused them of marching while shouting slogans without any prior permission and not maintaining social distancing and not wearing masks. Additional Chief Metropolitan Magistrate Vidhi Gupta Anand said that the prosecution had failed to prove guilt of the accused persons and there were innumerable lapses in investigation conducted by the IO. Delving into the prosecution evidence, the court said that only 3 witnesses had been examined and there were several contradictions in their testimonies which questioned their truthfulness. An amendment application has been filed before the Allahabad High Court in a pending PIL plea filed last year against the exhibition of the movie Adipurush. The plea states that portrayal of characters such as Ravana and Lord Hanuman in the movie is completely divorced from the Indian civilization. The amendment plea has also objected to the dialogues written by Manoj Muntasir Shukla, terming them to be ridiculous, filthy, and against the glory of Ramayan Yug. Essentially, this PIL was moved by social activists Kuldeep Tiwari and Bandana Kumar last year in December. Though the High Court, while hearing the matter in January this year, had issued notice to the Central Board of Film Certification, no reply has been filed by the board in the matter. In this regard, the amendment plea now prays for a direction to the opposite parties to remove the objectionable dialogues and scenes from the film which depict the religious characters in an ugly manner. In related news, as you know, another petition before the Delhi High Court against the film is tentatively listed for hearing on June 30th. Stay tuned. The Patna High Court has dismissed a petition filed by the management of Professor Vijay Shankar Rai Mahila College, Sherghati in Gaya for retrospective affiliation of the college from academic year 2020-21. The court also declined to issue a directive for a special examination for the students of session 2019-20. Justice Anil Kumar Sinha said that the doctrine of legitimate expectation, as argued by the petitioner, was not applicable in the facts of the case, as there was no representation on part of the state that the college could admit students, while the proposal of affiliation or recognition was pending. And now coming to an update on the KGF song copyright infringement case. As you know that MRT Music has filed an FIR against Congress leaders Rahul Gandhi, Jairam Ramesh and Supriya Srinathe over the alleged copyright infringement by the use of song from the movie KGF Chapter 2 in the promotional video for the Bharat Jodo Yatra. The Karnataka High Court today reserved its order on the petition filed by Congress leaders seeking to quash the FIR. A single judge bench of Justice M. Nag Prasanna reserved the order after hearing both sides. MRT Music has also filed a civil suit in which a trial court earlier directed the blocking of social media handles of the Congress Party and Bharat Jodo Yatra, but the order was lifted by the High Court in an appeal filed by the Congress Party on an undertaking given by it to take down the offending videos. The Kerala High Court has directed the Director General of Police to take steps to remove online images and details of a woman who is a victim of offences under the Immoral Traffic Act. The petitioner had approached the High Court for removal of online content having her name and images circulating on social media, which had resulted in humiliation and cyber attacks on her. She also informed the court that though complaint had been preferred by her to the state police chief for removal of her images, name, videos, and defamatory articles online, no steps had been taken so far. Taking note of the submission of the petitioner that circulation of such content on social media was violating her right to privacy, a single bench of Justice K. Babu directed the Director General of Police and State Police Chief to remove the online media links pertaining to the petitioner. The court significantly observed that privacy is the constitutional core of human dignity. In another update, the Kerala High Court has held that innovative venture of using artificial intelligence cameras for detecting road violations cannot be discouraged merely because of allegations of corruption in implementation of the project. A single bench of Justice P.V. Kunhikrishnan observed that there may be objections regarding transparency of the project. However, those were to be dealt with separately. The remarks were made while hearing a plea where the petitioners sought exemption from wearing helmet while riding two-wheeler on medical grounds. Recently, two Congress leaders had approached the court seeking a court-monitored inquiry into the project for automated traffic enforcement system, alleging corruption and violation of privacy. There, the court had directed the state government not to make any financial payments to the contractors until further orders. And lastly, quashing an FIR for offences under the POCSO Act pertaining to penetrative sexual assault on a minor, the Meghalaya High Court has held that a 16-year-old is capable of making a conscious decision with regard to an act of sexual intercourse. The bench was hearing a plea seeking quashing of an FIR for offences, claiming that the act was not a case of sexual assault but was purely a consensual act as the petitioner and the alleged victim were in love with each other. The petitioner contended that the survivor had herself affirmed that the sexual intercourse took place with her consent and there was no force involved. The court determined that the survivor's statement was in support of petitioner's case despite her being a minor. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us.